Understanding public-private partnership, one of the interesting ways of awarding government contracts, though something that is not very common, but yes, has been accepted practice, is the Swiss challenge method or the method of unsolicited proposals that the government can actually undertake to award contracts. Now, usually we have two methods of awarding government contracts. First is the top down approach, which is the tendering process. The tendering process is a process where the government comes up with the tender, with the proposal. It requests bidders to actually submit those proposals to the idea or requirement that the government has already finalized with. So the government will come out with, say, look, we want a road project, we want an airport to be built, we want a port to be built. Who is willing to tie up with us? And this is the project structure. Sometimes they would want the private player himself to design the project, build the project, and operate the project as well. Or they may have some kind of parameters of saying this is the kind of growth that we are expecting, to which the bidders will submit the proposal. So this is generally the top-down approach of government contracting. There is this very interesting approach of what is known as the bottom-up approach, which is probably the citizen-centric approach to government contracts, where the citizen actually comes up with an idea or the proposal and he places before the government, saying that why don't you actually take this proposal forward. So the bottom-up approach is called the Swiss challenge approach. And this is where you will notice that the government does not come up with a tender. It comes up with the tender at a later stage when it has given principal approval to the project. But the idea of the project, the proposal of designing the project, comes from the citizen or the corporate citizens, as the case may be. So in this kind of an approach, friends, the first question is whether this approach is valid in India or whether it is something that governments cannot actually operate upon. Now, you obviously are looking for some kind of a legal framework to allow Swiss challenge method, because please note, it can randomly probably be misused or abused at times. Second, you ought to know how the process of Swiss challenge has to be implemented or operationalized, and hence whether the law actually permits Swiss challenge or not is something that we'll have to first test. Now, in this case called Ravi Development versus Sri Krishna, it's a 2009 Supreme Court judgment. Ravi Developers, a real estate company, obviously, presented a suo motu proposal to the Maharashtra Housing and Development Authority. They want to develop certain plots of land in the Mira Road area in Thane, Maharashtra. And the Maharashtra Housing Area Development Authority, obviously, this was a proposal that is coming from Ravi Developers, so they said we'll accept this under the Swiss challenge method. Now, once you look at the Swiss challenge method, friends, you will understand that suo motu proposals, that is self-initiated proposals or ideas of government contracting, can be welcomed. However, the process of ensuring transparency and accountability of the project is something that is inevitable in government contracts. And hence, the project details were circulated by the Maharashtra Authority. They give an in-principle approval to this idea presented by Ravi Developers. And they said it's a suo motu proposal, it is not our idea. And you will notice that there is very interestingly the right of the first refusal clause in such projects. Now, this is very, very important and this is very, very critical. Now, the right of first refusal very clearly means that, look, you will now open this proposal submitted by Ravi Developers for a challenge. Is there any other person? So you will put an advertisement, you will put it for public scrutiny. You will probably have a public hearing if necessary. You will have a public consultation if necessary. You will have an expert committee that will decide if necessary. All these would be relevant and important for the Swiss challenge method to be acceptable. Now, the first thing first is that please note, the one who proposes always have the right of first refusal, which means if there is a proposal that is received which is in challenge to the existing original proposal made by the citizen, then Ravi Developers, who has submitted this idea, will have the right of first refusal, right? So they will have the right to match the bid submitted by any other person. So it is like open competitive bidding process. Ravi Development will have the first right to refuse. If they match to the winning bid, then they will have the first right to implement the project. That's how Swiss challenge. The word challenge is competitiveness in government contracting cannot be compromised. Transparency and accountability of government contract can never be taken away. It's a primary rule, and arbitrariness, unfairness, and unreasonableness of such contracts cannot be compromised, and it will be held in violation of Article 14 of the Constitution of India. So tendering is followed in a process after giving in principle approval to the suo motu proposal, and there is public scrutiny, there is public consultation that will have to come into process, and then once they open it up for bidding process, Ravi Developers, who is the first original person who was given the idea, will have the right to match up to that winning bid. If he refuses, that is Ravi Developer refuses, then the project can be awarded to the winning bidder. This is the ordinary way in which Swiss challenge is permitted. This is how it has been followed and practiced. And the Supreme Court in 2009 said, I think this is also a very good method, and the government can definitely adopt such methods. There is no problem. However, the Supreme Court laid down a few principles that they thought should be important in the Swiss challenge method so that it is legal, it is permissible, and it is valid. The first thing that the Supreme Court said in this Ravi development case was that it is important that the authority publishes the proposal of Swiss challenge quite well in advance. It should not be done in a hurried manner. So people must have time to read, evaluate, scrutinize, and give comments on the Swiss challenge method. So it must not be something that should be done in an urgent manner in which citizens' participation is ruled out. Right. So advance publication of the proposal and the idea of the contract and project must be something that has to be done quite well in advance so that citizens can participate and there can be competitive proposals that can also be invited. So that is the first ground which the Supreme Court has laid down in the Ravi development case. Second, the nature of the project is quite critical. Right. So the nature of the project should be such that it is something that has come through the Swiss challenge method. Now, it cannot be an ordinary project which the government has already tendered upon, or in the past the government tendering was the process through which such projects or contracts were awarded. So this must be something very unique, something not very thought about, something on which the government had no previous idea, project, tender, or any kind of experience in executing the same. So it has to be unique in terms of the project requirement as well, right? Third, I think what is important is that the private person who wishes to make the proposal on Swiss challenge should not have been approached before by the government. That's very clear, right? So the private player who comes for the Swiss challenge method is someone who has not worked with the government on the similar project before, and this is to substantially say that he has not had any previous allegiance or kind of idea with the government. So this is also very important in terms of the Swiss challenge method, right? Also, the nature of the project or the field of the project or the categorization must be notified before, right? And this would probably help potential bidders who are coming to the challenge prepare to match up to the proposal submitted by someone like Ravi Development. So that's also something very important. And ample opportunity must be provided to everyone to participate in the competitive bidding process. And the rules should be very clearly framed. Is also something that has been laid down from time to time, right? So these are some of the precautions that have to be followed, and the Supreme Court said if these precautions have been followed, then the Swiss challenge method is also something that the government can definitely adopt. And the courts have said that that is also a wonderful way or idea in which government contracting can be approached, especially even though if it's in the PPP mode. Now, one of the interesting aspects of Swiss challenge has always been something that you see under the Insolvency and Bankruptcy Code. Now, if you see the Insolvency and Bankruptcy Code, where there is this opportunity to take over bankrupt and insolvent companies, usually the proposals to take over these bankrupt and insolvent companies are unsolicited. They come by their own, right? And they come up with a resolution plan as well and place it before the NCLT, that is the National Company Law Tribunal. And based on that, you will notice that it is taken forward too. So even under the IBC code, you will notice that unsolicited proposals are generally entertained. That is the process in which taking over of companies under the Insolvency and Bankruptcy Code is entertained. It is valid, it is enforceable, and I think the future of Swiss Challenge is here to stay. The only thing is that the development authority of the government must be very clear the basis on which Swiss challenge method is going to be awarded for ensure transparency, competitiveness, and accountability of the project. And with that, I think such kinds of contracts are something that can always be taken forward with. Going on to understanding whether there is a legal framework for public private partnership in India. Uh, Very often than not, one tries to evaluate legal frameworks for contracts, and hence the discussion all through has been the Indian Contract Act 1872, the Sale of Goods Act 1930, the Specific Relief Act of 1963, and several on. We have discussed so many other legislations, including the competition law. Now, I think the public private partnership is a very important framework. It is quite a sizable amount of contracting that happens in this country. There are so many numerous projects, both sector and state. Now, I believe that the public-private partnership projects in India would actually be more than 100 such projects that have entered into from time to time. So, it in terms of the space or the sector in which public-private partnership exists, in terms of the quantum of economic activity that these projects have impacted in the country, one would have thought that a legal framework for this project would be passed in this country. However, I think in India, I think we have allowed contract law or the basic contractual provision to dominate, and we have not created a special framework. At least there is no central law that looks at a framework on PPP. There have been some guidelines issued, say, by agencies like the NITI Aayog. The government has established the PPP Appraisal Committee so as to evaluate the proposals both at the state and the central level. There have been ministries and departments that have designed model PPP concession agreements like you have it in the highway sector. This is to allow a model contract to be entered into so that there is no disparity, changes, amendments, and variations and uncertainties in these contracts. So a lot of this activity has already done, but no legal framework was brought in. However, if you compare India to the United Kingdom, in the UK in 1997, they enacted a legislation called the Local Government Contract Act. This does allow local governments to enter into PPP. It is a facilitating legislative provision to allow local governments. And I believe that in India, local governments play, as I told you in the past, very critical role, and they can actually raise a lot of infrastructure through the public-private partnership mode. Now, just to look at the state legislative actions on PPP, you will notice that in Andhra Pradesh, you have the Andhra Pradesh Infrastructure Development Enabling Act of 2001. Assam has a policy. Bihar has an Enabling Act of 2006. Goa, applies PPP in most projects that are sponsored by the government or the public sector undertaking. The most interesting legislation is the Gujarat Infrastructure Development Act of 1999. It was amended in 2006. This is one of those legislations that actually facilitates public-private partnership, and that's one specific legislation that has been often referred to as the legislative framework for public-private partnership projects in India. Karnataka has a policy that facilitates the same. Odisha also has a policy. Punjab has enacted a legislation called the Infrastructure Development and Regulation Act. Rajasthan has developed a fund, and West Bengal has a policy. So, between the policy and the act, you will notice that few states run PPP through the policy framework, and few states run PPP through the legislative enactment framework. So, I think the governments have the free hand to select sectors, projects for a public-private partnership initiative. They have committees that can actually monitor, scrutinize the amount of PPP projects that can be done, and hence it is done in a very careful manner today, so as to balance the interests of the government and the public sector, as the process is. Now, if you look at the process of the public-private partnership, friends, it's quite complicated and time-driven. It takes a lot of efforts for the governments to actually bring a PPP project into place, because we don't want to repeat the mistakes of the past. And hence, it would take anywhere between 2 years to 4 years for a public-private partnership project to be executed and the project to commence. Actually, that is the timeline in which most of the projects have been brought into existence. So the broad processes involved are in this framework. Please note they're very broad. They're not very detailed and specific, but just to give you an idea of how the PPP project is actually conceived and designed. First is it goes by a project identification, where you can do it in which city, which area, which sector, whether it is water, airport, so on and so forth. Again, you will notice that airports are in the central union list, so only the central government can decide, though it requires the state government's consent and approval to do the same, because land is something that only the state governments can actually identify with. So project identification is very, very critical, which areas can be done and which cannot be done. For example, a lot of these smart city projects today are something that are outsourced. They're not necessarily under PPP, but the smart city projects or smart city missions have been encouraged to at least build projects in the PPP mode. So the cities have been kind of focus area right now, because the big infrastructure projects have already been brought into the PPP formula. Second is to, once the project has been identified, that the feasibility study is very, very critical, because feasibility study is about whether it can be viable under, say, an outsourcing mode, whether it's viable for a complete government execution, operation, maintenance, or should it be under PPP. If it's PPP, will the private sector will be interested? How can you make this very attractive to the private sector? How long? And so the feasibility study becomes a very critical part, because the feasibility study will not only look at economic feasibility, it may also look at environmental feasibility as well. Because see, the environmental impact of projects, though it's government or PPP, are very, very important and critical. So I think the legislative framework and the public concerns of feasibility have to be taken into consideration as well. I think sensitization of local communities are also very, very important. Taking them into confidence also becomes very important for the successful execution of the public-private projects, right? Third is, why PPP? This has to be answered. It's very important. Is it because the government does not have money to invest in this, or is it because the private sector will bring in more efficiency in terms of operation and maintenance? So, whatever may be the motive or the reason for projects to be granted under PPP, it should be money driven. And it should actually result in some kind of economic propulsion of activity once it is there or granted to the public-private partnership. Otherwise, the private players will actually exit. They will not find this feasible at all. So it should generate revenue. It should have a revenue model, a robust revenue model. And I think the calculations of revenue becomes very critical. Now, let me tell you why money driver is important, because remember, tomorrow, if you want a competitive process in the public-private partnership space, if it can add value to the contractors, they will be interested in. So that will be greater competition. Otherwise, you will end up having just one or two bidders for this public-private partnership initiatives. It's very important that the political, economic, and social risks are managed in a public-private partnership. I think the government has a major role to play in management of risk, and that kind of certainty can only drive the success of such projects. And hence, the government must actually invest in management of all the three forms of risk: political, social, and economic risk. The fifth, I think, process is to enter into a robust concession agreement. Once the private partner has been identified through a competitive bidding process, the concession agreement, that is the title of the agreement, that is the framework agreement, that is the master agreement that goes into public-private partnership. It must be very appropriately negotiated, reviewed, and drafted. I think a robust contract is a well-driven contract. If the contract is properly entered into, it's not one-sided or unfair, or it is not taking into consideration the existing challenges with other projects, then the contract becomes very weak. So robust contract can drive a very, very robust execution of the contract, because this is a very long-term contract. What is also important is the project expectations. Friends, this is a problematic situation in most cases. Project expectations are not clearly defined by the government. Most of the time, it's left to the private player to identify and actually complete it. There, I think a lot of time mismatch can happen. Project expectations, along with project completion schedule, are something that have to be attached to the concession agreement, and they have to be also carefully negotiated and agreed upon. Unreasonable expectations of project completions would be actually a hindrance to the project. It will actually start with a lot of distrust and mismatch of expectation. So I think delivery schedule should be very, very reasonable. It should be flexible as well. What is important is not that the project gets completed on time. What is important is that the quality of the project is not compromised, while time is made important for the completion of the same. So I think quality of these projects are very important. See, the quality, why I say, is because these infrastructure projects should be world class, and we expect the private player to actually get the world class technology, get the finance that can actually make this project a qualitative one. It should withstand the test of times. You don't want government projects like execution, because very often we have understood that government project like execution sometimes are affected by quality, and that is probably one of the main reasons for going into the PPP sector. Of course, selection of partners, I believe that is also critical, because do you want the private player to also have a consortium of partners? More the partners, more the problems or challenges of driving consensus decision making. So you will notice that at the start of the PPP process in India, there was a consortium of bidders in the private public space. The private players were not one; they were actually two or three, or sometimes four. Right now, I think India has seen quite a bit of experience in PPP. So we are permitting just one player to partner with the government. So that is something that we have always seen as a development of the sector and development of the contractual maturity that we see today. Tariff fixation is also critical and important. For example, you have seen the problems of electricity tariff fixation. We have seen it in Delhi that electricity now is unfortunately given free. Tariff fixation can be a social and an economic risk or a challenge as we go forward. We have seen a lot of protest at toll booths for where tolls have been increased, or where there is an expectations of the citizens that the tolls should be given free. So, toll-free roads is what the citizens would demand, because they would not allow the private player to actually recover his investment. In the airport sector also, we have the Airport Economic Authority that would fix user development fees in the airport. We know that this has been a challenge. Whenever expansion takes place, the user development fee goes high. The customers who are using the airports always find it to be quite pricey. So there is a social and an economic challenge over there. How do you fix the tariff? How do you revise the tariff? Tariff needs revision whenever there is expansion, whenever there is additional investment, whenever there is an additional maintenance cost, or whenever there is price escalation of essential, maintenance and operation costs, including labor and raw material. And hence, for tariff fixation, you will notice that in the electricity sector, we have come up with a regulation on tariff. We allow the CERC, that is the Central Electricity Regulatory Commission, or the State Electricity Regulatory Commissions, to actually determine the tariff which consumers have to pay to either the government or to the private player. So these are independent regulators. They can act on behalf of both the parties. They can actually act very reasonably, like a judicial commission or a judicial quasi-judicial authority can do. And I think that is a critical part of, because that cannot be fixed in the contract. That has to be fixed by public policy concerns. And hence, tariff fixation is an important process of how to make a PPP a successful one. And hence, the policy can drive tariff. Policy can be something that these adjudicatory agencies can actually fix. And I think tariff fixation becomes a critical component of balancing the public interest as well as the private interest as we go forward. Finally, coming to the process of the contractual management. Contract can be entered into, but how it should be managed, I think it should be managed by the board of directors or the board of managers who actually manage the PPP process. You need very, very professional administration, professional management, because some of these sectors are very, very technical. For example, electricity sector. Some of these sectors can demand a lot of attention from professional business managers. They need competency at the management level. So government interference in such projects should be minimal. They should be driven just on public interest and nothing more than that. So the contractual management phase becomes also an important phase because you do need to break deadlocks between the board. You need to actually find some resolutions to the deadlocks, and those are something that the management should be able to drive forward to. So I think contractual management is critical. Government must appreciate contractual management. They must bring in professionalism to facilitate better project execution in the PPP sector. And I think that also is something that the government owes a responsibility as well. Don't forget that contractual management is not a compromise for corporate due diligence and corporate compliances. The PPP process is definitely something that could be regulated under the Companies Act, because the special purpose vehicle that is established on the PPP could be a private limited company, it could be a limited liability partnership, and hence corporate compliance also something that have to be managed. They have to be complied with, and hence the regulators like the registrar of companies and others in the government can also monitor the public-private partnership process. Don't forget that when we talk about contractual management, we are also talking about some leverage of accountability of the private process, and it's not pure private contract which is to be kept in the private domain. There is a public concern because you are actually executing public work. Citizens are going to demand accountability, are going to demand answers. So the contractual management should be perceived in a manner that has an absolute rule of transparency and accountability to the citizens at large. Right? That's the process in which contracts should be taken forward in the PPP sector.